Hey, everybody, and welcome to the video portion of You Should Write a Book About That. We are really excited to be bringing the show to YouTube and to video, but we are going to continue to honor our favorite medium, audio. And so you can still find us on all of our podcast platforms where you listen to podcasts. Today, I'm talking to Matt Speredelozzi. He is the deputy public defender at the county of Santa Barbara, and he has a really incredible long resume. And he is very devoted to cases with wrongful convictions. He's got a lot to talk about with us today about a particular case of his that he did overturn based on DNA, and he's going to get in a little bit more into details on that. I could try to tell you about crime labs and statistical evidence until I'm blue in the face, but I am just not a great scientist. So I'm going to turn it over to Matt. Matt, it's so good to have you here today. I mean, you're this deputy. You told me you play the banjo. You live on a ranch. You're kind of like coming into San Diego like Clint Eastwood with these overturned convictions. It's really fabulous.
Well,
So
it's good to be here. Thanks for having me.
tell me how you got into your career with this particular area of law.
Well, in law school, I wanted to do trials. That was kind of like my goals to be a trial attorney. And I knew that it was criminal law where you did more trials rather than civil. And that's why I went into criminal law. I did internships at both the public defender's office and then later at the district attorney's office. So as a like intern prosecutor. And then with this particular case, I was, a private, a lawyer, fairly new. I think I'd been 2 years out of law school and got a referral from a law school friend. And this case kind of came across my desk, and the client decided to hire me, and we connected. So that's how I got involved in this particular case.
It's pretty amazing that something landed on your desk that is now history. If you think about it, it's the first of 256 cases that you're discovering someone sat in jail for 10 years over science that probably shouldn't have been allowed to slip through the cracks. Do you want to tell us a little bit more about that?
Yeah, it is really uh, just to your point about how weird it is. I mean, in a million cases, this has just got to be one in a million as far as the match between me and the client and the issues that were presented, particularly the DNA issues, and my skill set that I didn't even know I had to analyze and look at DNA at the time. It was I've always been kind of a math nerd, and it's very mathematical, statistical area of forensics, and it just clicked with me. So yeah, I mean, it was like lucky for me to get a case that helped me and helped me develop my career and my practice, and lucky for the client that he got an attorney who understood the science behind what was going on and was able to successfully challenge it. Um,
It's
so
interesting that murder is so human, right? It's something that happens in for a variety of emotions and reasons, and yet the conviction is so it's scientific. But what you discovered was there was some profiling on this 10 years ago where there really shouldn't have been.
Well, yeah, I mean the issue was the DNA match on a pair of gloves. So the the issue became whether or not um, Florencio or Jose's DNA was found on a pair of gloves. The pair of gloves were clearly uh, used by one of the perpetrators of the killing,
Hmm.
and the question is whether he wore the gloves the night of the killing, during the killing. And of course, the prosecution used scientific evidence, DNA evidence, to try and convince the jury that he was wearing those gloves. And That's a pretty difficult thing to overcome from the defense by saying, they're wrong about that the DNA evidence is wrong and that you shouldn't believe it. Um, but I think there are public perceptions of DNA that are just wrong about how reliable it is of a way to identify somebody. It's really not as reliable as the general public thinks, at least in certain contexts.
The way you were
Particularly,
describing it by, there's 28 strands or 28 places where it has to match.
yes, essentially they're looking for genetic markers to match. So,
Genetic markers. Yeah.
so what they do is they take an evidence sample. Let's use this case as an example,
Mm-hmm.
from the inside of the glove. So they actually swab the inside of the glove, using a forensic swab. I forget the name of what they call them, but it kind of looks like a Q-tip. And then they put that into a liquid extraction form, and then they mix a chemical in there that amplifies the DNA, which means there's very small amounts of DNA, and the chemical makes that DNA replicate itself
Mm.
exponentially, 2, 4, 8, 16, 32. And that amplification process makes the DNA more voluminous in the extract, and then they put that they kind of circulate that through a gel that's called electrophoresis, and that
Mm.
separates the DNA markers and kind of identifies them. And so you get a profile. The DNA profile is, millions or billions of genetic markers, and they isolate. It used to be, I think it was 12 or 13 back in 2011 when the trial occurred, but now it's, I think, 25 because they've advanced the science. So they isolate these markers, and then they take the suspect profile and do the same thing, and they line them up and they try and see if the suspect profile, if the same numbers in those genetic markers match the markers in the evidence sample. And of course, if it's your DNA, if you're the one who contributed the biological material to the glove, they should match at every single genetic marker. Now, the problem in this case, and one of the reasons that I contested so vehemently to it at the trial and then later was able to get it overturned, is that the client didn't match at every single marker. In fact, he was inconsistent with. They took it's fairly complicated. They took multiple samples of the glove. He was inconsistent on multiple markers in multiple samples,
Mm.
and they still said he was included. This was a practice that was used in the San Diego crime lab from roughly, I think, 2003 to 2011, where they would selectively disregard markers where a suspect was inconsistent. And the justification for that was that the evidence sample was only a small amount of DNA. And so they said they may not have gotten the full sample, the full genetic data at that particular marker, and so they could just disregard it. Now, the
Hmm.
problem is that they saw, or they used to look at the comparison first and see which ones were inconsistent and kind of use that as a basis to disregard the markers. And you can see that logic is kind of circular.
Mm-hmm.
And, you know, obviously it has problems. So
And
that's
he had a witness. He had a witness that said he was there, right? But that witness was mentally unstable. Is that correct?
yeah. There was a witness who identified him as the shooter. That was the other piece of evidence. Um, that witness, for a myriad of reasons, was not very reliable. He had admitted to he was first of all he was, I believe at the time, he was 13 at the time of the shooting
Wow.
when he made the observations, which was 2 years before the trial. He indicated to police that he was smoking a blunt and drinking 40s at the time he made the observation. He
Okay.
he also said that he basically like lied about you know, about what he saw. His statements as to what he saw were just totally inconsistent with what all the other evidence showed what happened in the case. He was, when he first made the statement, he had been arrested for a vandalism, and he admitted at trial that he only made the statements implicating my client because he thought he would get out of his vandalism arrest.
Oh my
Um,
God.
there was all kinds of issues with his statement. He later said that he lied to the police about implicating the client because the police officer, um, they like coerced him into saying this stuff. They never had him pick out my client out of any kind of photo lineup. So they just kind of assumed the person who he was talking about was my client based on the name. At one point in the trial, we asked him which detective interviewed him, and he pointed at the detective who interviewed him and called him by a different name, the name of some other detective that didn't interview him. So,
Wow.
and the judge made remarks that it appeared as though he was intellectually disabled, and he may have been, he may not have been. I can't really opine as to that, but um, he definitely had some limitations.
So explain this to me, Matt. It doesn't seem to me that has changed at all in the last 10 years. These inconsistencies in human opinion, in witnesses, in evidence. I mean, you hear about it a lot that kind of stuff gets accepted, discounted. But it seems to me that the DNA breakthroughs that you're looking at now and experiencing in San Diego County could be something that trumps the inconsistencies in the human evidence. Is that correct? Can it help it? Can it help these people? Because apparently there's a lot of innocent people that could be going to jail based on what was it that officially put him in jail for 10 years? What was the like nail in the coffin for Jose?
Well, it was the DNA evidence that really essentially got him convicted. There were two trials. First of all, the first one, it was a hung jury. It was the vote counts was 9 for not guilty and 3 for guilty,
Oh, wow.
and then they redid some of the DNA evidence and came back with what they considered to be more compelling DNA identification evidence against Jose, but again, using the same methods, the same kind of outdated methods that were later repudiated or even contemporaneously repudiated if you look at the history of it.
How many people in the jury, though? You know, I was just talking about this with my daughter. Like, I was listening to this comedian, and he was talking about like when you go in and you go for jury duty and you look around, you're like, oh wow, this is like, this is humanity and its finest, right? Why would those people? I wouldn't have any clue if I was on this case. Why would that jury even know the intricacies of DNA? No one probably did anyone sit down and explain it to them? What was it explained in great detail or
Absolutely. During the jury trial, in this particular case, as an example, for generally speaking, um, there was at least 3 days of expert testimony about
oh wow.
DNA
Okay.
evidence. So the prosecution called an expert who testified and explained the process, the analysis, and the conclusions. And then I cross examined that expert using charts and graphs. And a lot of the direct and cross examination is educational
Mm,
background and explaining in as best we can lay terms to just folks from the community how to interpret this evidence, whether to believe it or not believe it. Obviously, the DA wanted them to believe it, and I wanted them to be skeptical of it. Um,
mm,
and this education process is done through the testimony of the witness, as well as admitting documents, charts, graphs, um, I remember when I was preparing, I made a chart of the profiles and the numbers, and I put they were all in black type, and then in red type I put the areas where my client was missing, where he was not included,
Wow.
and I asked if you don't think if this was a if you don't think there's any missing data, then he has to be excluded. He would have to be. And the expert for both the prosecution and the defense, both experts had to agree, yes, he would have to be excluded. So the only way they can include him would be if they would agree that this profile they got from the gloves was missing data.
Amazing.
And that was, yeah, that was a pretty powerful. But yes, the jury has to be educated, and that's not just DNA. On all aspects of things that are beyond common
Mm-hmm.
knowledge, we call experts. We call experts to educate the jury and explain the
Bring
evidence,
them in.
and hopefully they can understand
You
it.
had no idea that you were going to be having a law and science career at the same time. And here's Jose sitting in jail for 10 years and now he's out. You want to eventually write a book about this. And I know when we talked about it, there was a lot of, contemplation about, is it a book that involves the science of it and the legalities of it and how intricate that is? Would that be boring? Or is it more of an emotional story about this concrete builder with 3 children who was out of gangs for all intents and purposes, as far as you knew, that suddenly has been implicated for murder and now spends 10 years in jail? And you're the guy that comes along, lands on your desk, and you get him out of jail. That's sort of the hero story. But you sort of feel like then you'd be telling Jose's story too. So you're like, well, maybe Jose needs to tell the story with me, but Jose's not a writer. So what do you do?
Yeah, I know, and I thought about that as far as his involvement and how to get him involved, because I really think his perspective is important. But even more elementary than that, this I don't know, this kind of feeling I have about telling stories, because
Mm-hmm.
I don't know if the general population knows this, but almost every trial lawyer knows this, that being a trial lawyer is being a storyteller. I mean, that is what we do.
Mm.
We take our client stories and we tell them to a court on every day, whether it's to a judge at a motion or to a jury at a jury trial. We want to bring a compelling story that people can connect with on a deeply emotional level. And my thought about writing this book is, I'm kind of the science nerd who really did a nosedive into this DNA stuff. And if I write a book about all the intricacies of DNA, I'm not sure that's something that has a strong emotional connection for a lot of people. And that's, quite frankly, not a good story. Good stories involve good emotional connections, not DNA, intricacies and, minutia. So, I guess the challenge, and this is true when presenting on DNA at a jury trial, the challenge is, how do I get people, the public, anybody audience who wants to participate in hearing this story, how do I get them emotionally connected in complex DNA?
Mm.
That's the challenge.
Well, I
How do I
think it's
get them
that
emotional?
base that what I was mentioning sort of in the beginning is that it's scientific, but it's about a human being, right? So their life, I mean, for 10 years, they were not with their children. They were not with their wife. They didn't make any money. Now you're saying he's back in society and back at his job. That's great. But while all this was sort of, because for 10 years, did it sit fallow?
No, this was always
Always
active.
going.
This is a long story with a lot. The DNA and the story, the DNA is just a small part of it, really.
Wow.
That's the part that really got him out.
Mm.
But the story involves all kinds of ups and downs. I did write like an outline about it, but There were 2 trials, 1 appeal, a federal habeas case, multiple court of appeals cases, 2 published opinions. And if anybody in the legal field knows that just because you go to the appellate court doesn't mean you get a published opinion. A published opinion meaning that's law, that's citable now in other cases. That is actual law that people have to follow, that courts have to follow. Most cases are not published even after they go to the Court of Appeals.
So you've been published.
This one involved, well,
You're
not me, the justices who wrote the opinion.
Okay.
My name is on there as counsel,
Yes.
but there are two published opinions, one from the Ninth Circuit Court of Appeal on the issue of habeas corpus and mootness, believe it or not, and the other one on basic discovery rights in the context of forensic DNA.
Wow.
And that's from the Fourth District Court of Appeal, state of California. So state published law and federal published law in the case. But meanwhile, just a lot of fine points of really, almost winning and then being heartbroken over and over again over a period of years. For example, we won the first trial insofar as we earned a hung jury, and it was a 9-3 split, 9 for not guilty, 3 for guilty. So we had the majority on our side for not guilty. Thereafter, the court had an opportunity to set it for a retrial, but instead dismissed the case in the interest of justice, stating that the prosecution failed to meet their burden of proof. And we thought we had won. This was in October of 2010.
Wow.
Jose had been in jail 8 months, and I went and had a beer at lunchtime with my friend to celebrate when I got a phone call that said they were actually refiling a new case and now amending the charges. And that sparked a whole nother battle based on whether or not that would be allowed under double jeopardy, under constitutional principles. Just for one example, but there's many examples where we win something that you'd think would be the end and we can all go home, and then something shifts and we have to keep going. And just the emotional roller coaster of that was just, it was a lot.
But you stuck it till the end. So you have victory at the end of the day.
Well, yeah,
and now it's a thing. Now it's actually a thing. Like more of these people are coming forward because of this.
Well, yeah. So I'll explain that a little bit. When the DNA decision was made in that was actually also October, but 2018, where Jose's conviction was overturned because of this DNA issue. The DA in San Diego, they have a conviction review unit, and they identified 256 other cases where this same kind of faulty DNA evidence was used. And they notified all the attorneys on those cases. The media was notified. There was all kinds of coverage on it nationally. Yep. And that's not to say that all of these cases are overturned, because the first step is identifying that the evidence was used in their trial or to induce their plea. The second step is to determine whether that evidence is material to the conviction. And that second step is much more consequential, believe it or not. And in any event, they identified these cases. There is one other case where the conviction was overturned based on this type of evidence that happened after Jose's case got overturned.
How long had they been?
I don't know.
You don't know them?
I don't know that case very well. I remember seeing the article about it and calling the attorney on the case and having a short conversation about it. But I don't know that client. I know that they're out. They got out of jail. So, yeah.
Well, it's encouraging to hear that there's there's people like you that are out there in the world committed to science, being re-examined, and us just not sitting back on old processes that aren't working for, obviously, for people who, whether they're innocent or not, with these situations, like, will we ever know? We won't. But and so I really look forward to seeing where this goes over the next couple of years, and how it changes. The one thing I want to end on is asking you this. San Diego, this is happening. Is this going to spread to the rest of the United States because of this?
Well, yeah, it already has. The Texas Forensic Commission did. I might have got that name wrong. There's an agency in Texas that handles forensics. They've already done a similar review, as did Orange County. There are instances of the accrediting agencies for CODIS, which is the mechanism where you take a sample and search it against a national database. In order for a crime lab to do that, you have to be accredited.
Mm-hmm.
And the agencies that accredit these crime labs have already censured multiple crime labs for using this repudiated practice. That happened in Florida. It happened in Washington, D.C. I not because of my case, in fact, independently of my case. This was kind of a national issue between the time of about 2010 and 2018, where the science clearly shifted. This organization that's an FBI working group, the Scientific Working Group for DNA Methods, or SWGDAM, came out and published guidelines that said you can't do this anymore. But they were just guidelines. They weren't directives by any means, because all these labs, they don't really have anybody that they report to centrally. But FBI does publish guidelines for best practices, and in 2010, they told crime labs, this is not the best practice. The science has changed. And the accrediting agencies have kind of adopted those guidelines. But suffice it to say, yes, this issue has been a national issue. This is not just one case, and not just me and my little practice here and all
Having one win. Yes, exactly. No, it seems to be like it's a big change, and it's a necessary change. And I'm grateful that you came and talked with us about it today in your busy schedule. Thank you so much for being on the show.
Thanks for having me.